can see my screen.
Yes, I can see your screen.
Yes, I can.
Okay, so good. Okay, good afternoon. My name is Favor. I'm going to be taking this course for this diet, and we'll try as much as possible to try to cover up the syllabus. This is basically a theoretical course, so it's going to be explanation and explanation. And I'm going to like to have a very interactive class. So at some points, I'm going to be asking you some questions. So this course basically is business law, and today will be this is the first class, so to be the introduction, and we'll try to cover up the Nigeria legal system. That's the first topic on this course. So before I proceed, when we say law, what do you think we mean? Glory, please, I would like this class to be very interactive so that I will know you're with me. Hello, Glory. Can you hear me, Glory? Okay, so I'm assuming you can hear me. You're probably having a network issue. So when we say law, there's basically no single meaning that is universally accepted when it comes to law. When we talk about things like economics, accounting, and others, there is a universally accepted definition. But when it comes to law, there's no universally accepted definition. But then there are some definitions that are professionally accepted. I don't know if you understand what I'm trying to say. So, law can be described as a body of rules or principles, right? A body of rules or principles that is recognized by a particular state. When we talk about states here, it does not really mean the Edo State, Kano State, those kind of things. It means a geographical location that has constitutions and laws and rules, and probably shared values, right? For example, Nigeria, United States of America, states like that. So law is a body of rules or principle recognized by a state and enforced through institutions. From the material here, John Salmon defined law as a body of principle recognized and applied by the states in the administration of justice. So this body of principles or rules, they are not only recognized, but they are applied by a state. So for example, in Nigeria, there's a body of law of principles and rules that are contained in the constitutions, which can be said to be part of the laws of Nigeria. I don't know if you get what I'm saying. So this guides the administration of justice. So when they say this is justify, when you are going to the court, there are some rules that they are being looked at and say, okay, based on this and this and this, is this right? Is this justified? Is this carriage of justice and all that? So we are looking at the Nigerian legal system. But before we look at the legal system, we would like to know what are the sources of the Nigerian law as we have it presently. So when we say sources of law, this can be where the law originated for, or where the law could be found. So when we say source of law, it means two things: the origin of the law and where law could be found. So Nigeria basically sourced their law from the received English law, Nigerian legislations, customary law, case law, which is also called judicial precedents, and international law. So Nigerians source their law from received English law, That's common law of England. When we say received English law, it's basically all those laws that were received from our colonial master, that's the British, right? The Nigeria legislations, the customary laws, the judicial precedents or case law. Judicial precedent is trying to look at, okay, what have been what have been decided on similar issues. If, for example, there's a case between two people about something that is known in the law as at that time, and at the end of the day, the court said, okay, this is our judgment. So for future cases that are similar to that particular case, that case can be like a precedent as the judge of cases. I think you get me. So, common law. Please let me know if you can still hear me. Hello? Hello? Can you still hear me? So, common law is the body of law derived from judicial decisions. It is derived from judicial decisions and it is common to the whole of England as opposed to custom. So while customs are local, that's it applies to a certain group of people in England. The common law is like common to everyone in to the whole of England. I don't know if you get. The customary is it's peculiar to a particular set, why common is common to the whole of England. And it's simply okay, it's simply put, what we decide is fair today. Like what is commonly accepted as being fair today is determined by looking at okay, what have been considered to be fair before, right? So the common law is like what we all decide to be fair based on what have been happening. So the common law was introduced to England after the Norman conquest in 1016. I really cannot tell if you can still hear me, but I'm going to go on because the class is being recorded. So I'll assume if you cannot hear me, you can listen to the to the recording later um and get what you need from that. So it was introduced into England after the Norman conquest. That's the first king, first Norman king, which was William the Conqueror, set up the Curia Regis and appointed his own judges. Like I said earlier, the common law is common to the entire England, right? So it's not like a particular custom or a particular tradition, or it's not limited to a particular people. And it's still used to distinguish laws that have been developed by judicial decisions. That means laws that came about from decisions that was taken in the law courts, as opposed those that were statutes or written. You know, statutes are those ones that are being passed, okay, that were looked into, written down, and being passed into the law. But these ones are like, okay, this was what was decided before, right? It was decided before. And based on what was decided before, this is what is considered fair. So I'm going to do a summary material of the entire course. And send it to you very soon. So for now, I'm going to be explaining as I read along. So next is the doctrine of equity. The doctrine of equity. First of all, what is equity? Right. Equity means fairness, also means just, it also means ethical. So when you hear the word equity, you should know that okay, this simply means fairness, just, or ethical. So equity is a branch of law administered by the Court of Chancery. It's a branch of law administered by the Court of Chancery before the passing of the Judication Act of 1873 to 75, with the view of supplementing the common law rules by alleviating their harsh effects. So basically, the doctrine of equity is just saying you should not just follow the rule, you should try to be fair. So this set of laws were established to try to make the law fair, just, and ethical. So it was developed to address the harshness of the common law system. So it was developed to address the harshness of the common law system. The doctrine of equity is developed. That's a body of principle. As we all know, law is a body of principle, right? So the doctrine of equity is developed by the court to supplement, and so it was more like the common law was right, was based on what we all agreed to be fair. But then the doctrine of equity is coming to say, okay, there are rules. We know there are rules set down, but then we should not just follow the rules. We should try to be fair, just, and ethical. That's equity, right? So this was implemented to correct and supplement the existing common law. Involved in a case a court order. Then the specific performance. This is an order that a contract should be carried out as agreed. It is basically the court a person to do exactly what they promised in a contract. It's just like saying me and someone has a contract together. In the contract, I promise to deliver, probably I promise to deliver um a service, right? And at the end of the day, I'm not delivering that service. Then this order is issued to me that I should deliver on the service as promised. It's just like saying the person fulfill should fulfill what has been promised. Then the next is rescission. Rescission. This is a remedy in a contract. In a contract case, this is a remedy in contract cases. The purpose is to return the parties as far as possible to pre-contract position. So this is simply saying, let's cancel the contract and put everybody back to where we are coming from. Like, let's undo everything and pretend we never agree. So it's just saying, let's start from afresh. It's like a remedy to a contract case that say, okay, since there is no way to rectify this particular issue, let us just cancel the contract and let everybody go back to where we are coming from. Let us go back to where we started from, the pre-contract position. I don't know if you're getting what I'm trying to say. So then the last one is rectification. Rectification is a court order to rectify a document so as to reflect the intention of the parties to an agreement, right? It's like we both agree on A, but in the document it is reading B. So this is rectifying it, like a court order to rectify it from reading B to read A. So it was probably an error or something. We both agreed on A. But in the contract document, it is saying B instead of A that we agreed on. So the court is issuing out an order to say, okay, oh, since you guys agreed on A and the document is carrying B, let us rectify this and let it show B. It makes the order where there have been a mistake in the document so that the contents reflect the true intention. You know, if we agreed on A and it's showing B, it means that what the document is showing is like an opposite of what we agreed, or is different from what we agreed. So it's showing a different intention. So if someone should pick up that document, you will have like a different perception of what we agreed on. So it's basically trying to correct that document to reflect that, oh, we agreed on A. So the document should be showing A, right? So there are some remedies that were developed recently, right? One of them is the freezing order, also known as the Moravian injunction, and the search order, also known as the Anton Pillar order. So the freezing order is when there's a risk that one party remove all their assets out of the jurisdiction. So it's basically saying, I think you should have heard of things like, oh, they are frozen the account. The court has issued a freeze order on all their assets. So it's saying there's a likelihood that this party will be able to move out all its assets from this jurisdiction before the end of this case. So to avoid such situation, the court will issue a freeze order on their assets. So the freeze order is going to make it unable for the party to move their assets. So the search order is to allow the claimants to search the defender's premises. So these two are basically self-explanatory, is to freeze assets. Then search is to enable the claimant to search for documents. Especially since the court is a case, there is order, depending on the context of this. So the margin of equity are the guiding principle when applying equity. Bear in mind, we are seeing of equity. So when we talk about the maximum equity, is basically those principles that the court applies when applying, that guides the court when applying equity. It explains how and when equitable remedies are granted, right? And there are 12 of such maxims. The first one is equity will not suffer a wrong to be without a remedy. So when there's justice, when there's fairness, all these are synonyms of equity. It should not suffer a wrong to be without remedy. So once a wrong is perceived, there should be a remedy for it, right? The second one is that he who comes to equity must come with a clean hand. So the person bringing up the case, the person coming to ask for equity remedies should ensure that it's coming with a clean hand, that there's no dirty linen, there's no skeleton in the cupboard, all those kind of stuff, right? Will that might impede the judgment. So he who seek equity must do equity. It's just like saying, do unto others what you want them to do unto you. You seek equity, you seek fair treatment, you must be fair. You seek fairness, you must do fairness, right? Then the fourth is where the equity are equal, the first in time prevails. When the equity are equal, the first in time prevails. It's basically saying that when two people, right, have equal equities, the first person, the first equity, the first person is going to prevail. The first equity is going to prevail. Then the equity follows the law. Like I said, equity, the doctrine of equity is to supplement the law and correct the law. So it comes in play when the law is not being fair. So this comes to like it's following the law, but then it's a very fair process. Delay what it means in English. So when you delay, the purpose of equity judgment is going to be defeated. Then equality is equity. It's, there's no inequality in equity. So in equity there should be equality. And equity look at the substance, that's the intent. What is the intention of this, not the form. So it's basically saying substance over form. Equity looks at the intent, not the form. Equity looks on that as done, which ought to be done. So it's basically saying that okay, we are going to be looking at probably you're supposed to do A. Equity is going to look at it that okay, you have done A. You ought to do A. So we are looking at it that you have done A, right? Then equity imputes an intention to fulfill an obligation. It imputes an intention to fulfill an obligation. And where the equities are equal, the law prevails. It's a very key point. When equities are equal, the law prevails. You know, initially there was the fourth maxim was where the equities are equal, the first in time prevails. So you also bear in mind that where the equities are equal, the law prevails. And equity acts in personam, that is against the person. Please confirm you can still hear me. Any question before I move forward? Hello?
Yes, we can see your screen and we can hear you.
Okay. So we are going to be moving to the status of general application. But before I move, I would like to know, is there any question? Is there any question? Is there any confusion that you need explanation, or should I move? Think one, the next 30 seconds. Okay, I'm going to assume that there is no question. So, status of general application. These are laws of general application that was enforced in England on or before 1st January 1919. So they became part of the laws of Nigeria by virtues of various adaptation laws. It simply put, Nigeria went to borrow some old English laws, right? It's just like saying, okay, we have not gotten any law on issue A, and we have a case on issue A. Okay, from the laws established in England before January 1st, 1990, is there any law that pertains to this particular issue? If yes, okay, we are going to apply it in our judgment, right? And most of all those laws, they will remain laws in Nigeria until Nigerian legislation come on. For example, they have the sales of goods of 1893 is being applied in Nigeria. But then I think our sales but since already accepted so we have the acts, sales of goods, like I mentioned, bills of exchange, conveyance acts, and so on and so forth, right? Then they have English law extending to Nigeria. So these laws were made before the colonial, before the independence, as during colonial. So it was colonialism. So when you see like the decree, the criminal code, and the penal code, right? So all these laws were extended to Nigeria. Then remember the initial one, which was the applications, are the old English laws before that was enacted in England before 1990 to Nigeria was made by the English people for Nigeria between 1900 and Independence Day. That's 1st October 1960. Then the other source of law of Nigeria law is the Nigeria legislation. So the all the ones we have been discussing, the ones we got from the English, that's the common law, doctrine of equity, the status of general. So the legislation get together are those laws. Examples are and edicts used in the military, laws, the acts, for example, the Kama Company and Alias Manta Acts, and all other legislations. So the Constitution of the Federal Republic of Nigeria is like the supreme law of the land of Nigeria. It contains virtually everything. I think it's been updated sometimes, but then it's right? Law contains all supreme laws governing Nigeria. So this means that any law that is being implemented or being enacted that contradicts the constitution itself is void. So if, for example, in the constitution, sorry, excuse me, in the constitution, the legal age is 18, then an act now come up outside the constitution that say, oh, the legal age is 16. It means that when you look at the two of them, the constitution is the superior law. By virtue of the constitution, this other one, you understand, because it contradicts the constitution. So there are characteristics of constitutions. The first is supremacy. Like I tried to explain, it is supreme. It has a supreme power. Just like saying, oh, in the court system, the Supreme Court is the highest level of court, right? It's the same thing in the laws and all that. The Constitution is the supreme, is the peak, is the highest. So there are three aspects. The first is the Constitution provides that the Constitution shall be supreme and its provision shall have binding force on all authorities and persons through the Federal Republic of Nigeria. So it is supreme and its provisions have the binding force on all authorities. So all the provisions of the Constitution applies to all authorities and persons. It's not in line with the Constitution, and that is wrong or something like that. So everybody is answerable to the provisions of the constitutions, no matter the authority level, right? Then, no part of the Federal Republic of Nigeria shall be governed except in accordance with the constitution. It's basically saying almost the same thing. Saying, okay, when it comes to the government structure, everything must be in accordance with what is in the constitution. Then the subsection 3 states that if any law is inconsistent with the constitution shall prevail. If any law is inconsistent with the constitution shall prevail. By virtue of this, any law that contradicts the constitution is null and void, right? So, writing and rigidity. The constitution is a written constitution. Like, it's a book. I don't know how many of us have been privileged to see the constitution, that's the book itself. And the procedure for its amendment is special, that it is not easy to be amended. I think the last amendment was done in 1999. It can only be amended by two-thirds majority of the National Assembly, supported by at least two-thirds majority of the State House of Assembly. You know, when it comes to normal laws, there might be, okay, two-thirds of those present at the meeting, right, in the National Assembly can amend this or can pass this into law. But when it comes to the Constitution, it has to be two-thirds of the entire National Assembly. So it's not two-thirds of just those present in the meeting. If, for example, in a particular sitting of the Parliament, that's the National Assembly, they have less than two-thirds and they want to amend the Constitution, just by virtue of that population, they cannot amend the Constitution unless there's at least two-thirds in attendance that will be in support of such amendment, right? And when this does not apply to just the national, so if after there's two-thirds in the national that supports it, they have to be two-thirds at the state houses of assembly before making that amendment. So it is not, the constitution is not something very easy to amend. It is not flexible. It is rigid, right? So the second is federalism. Remember, the first was supremacy, the second is federalism. It is a federal constitution. So it divides the power between the federal government and the states government. So the federal government of the federation and the state government. So the federal government has the power to legislate on matters in the executive legislative list of the constitutions. The federal government has the power to legislate on matters in the exclusive legislative list of the constitution. Then both the federal and the state governments may legislate on matters on the concurrent legislative list. Don't know if you remember in government when we were taught exclusive list and concurrent list, right? So only the federal government has the power to legislate on the exclusive legislative list. But then the federal and the state government both have powers to legislate on matters on the concurrent list, right? Then another one is the separation of power. Don't forget, the first is supremacy, the second is federalism, and the third is separation of power. So the constitution separates the power among the three branches of government. That is the executive, the legislative, and the judicial. We know the executive are those the president, those elected into office, right? Then the legislative is the National Assemblies, those that make the law. The judicial are those that enforce the law, right? So none of these have power over another. That's why you see that the executive does not have the power to override the legislative or the judicial branch of government. So they act as check and balance of each other. The legislative can call the executive to order, right? The judicial branch can call both the legislative and the executive to order. Remember, the judicials are the courts, the legislative are the House of Reps, executives are mostly elected officers. That is the president, the governor, the local government chairman, and all that. Then the next is the rule of law. The rule of law. The Constitution has governance according to law. Sorry, excuse me. The Constitution has governance according to law as one of its cardinal characteristics and principle. Rule of law. There is nobody above the law. So the principle of rule of law have two broad aspects. So the first is the nemo judex. So him being a judge does not mean that he is going to judge his own case, right? That will bring about biases and subjective decisions. So a person shall not be the judge in his own case. And the second aspect is the audi alteram partem, which means that a person shall not be condemned without hearing, which also directly links to the right of fair hearing when you get to the fundamental human right, the right to life, right to this, right to fair hearing. So a person shall not be condemned without a hearing. So the first, that's why it's also termed that is innocent until proven guilty by the court of law or by something like that. So yeah, innocent. You cannot be condemned until you have been given a chance, a hearing. You have been entitled to fair hearing. So the next is the fundamental human rights. The fundamental human rights. The Constitution makes provision for the fundamental human rights which every Nigerian citizen is entitled to. Some of these rights include the right to life, the right to dignity of the human person, the right to personal liberation, personal liberty, the right to fair hearing, like I said, right, right to private and family life, right to freedom of thought, conscience, and religion, freedom of expression and the press, right to peaceful assemblies, then right to freedom of movement, and right to freedom against discrimination. So whenever any of your rights is being infringed upon, you can approach the state high court or the federal high court for redress, right? So the constitution basically lists out all those rights in which all citizens of Nigeria, bear in mind that we are talking about the Nigerian constitutions. We are talking about the Nigerian constitution, and we have talked about the characteristic of the constitution, right? Where the last where we stopped was fundamental human rights. So the next one is acts. Remember, we are still talking about the sources of Nigerian law. We have talked about the English law, and this is now under the Nigerian legislation, which the first was the Constitution, and this is acts. So, what are acts? These are laws passed by the National Assembly, consisting of the Senate and the House of Representatives. So when you hear, oh, that bill has been passed into law, that bill is now act like the new tax act, that's the tax reform act. So they were passed into law by the National Assembly. I know Nigeria operates a two-tier National Assembly, which is the Senate, that's upper level, and the House of Rep, which is the lower level. So there are processes that a bill is going to pass through before being passed into law. And once it's passed into law, it becomes an act, right? So decrees are enactments made by the federal military government. So in a democracy government, during the democracy period, they are acts because they pass through the National Assembly, the Senate, and all that. But then during the military regime, it was decrees. You know, militaries always have decrees. Decrees. It's just like an announcement made on a particular issue by a military government. That is the basic meaning of decrees. Then laws are almost same thing as acts. They are passed by the House of Rep, enacted by the House of Assembly. Sorry, House of Assembly of a state. Why the act is for the country being enacted by the House of Assembly, that is the Senate and the House of Representatives. The laws are being enacted by the House of Assemblies of a state. Then edit is the same thing as decree, but then the difference is decree is for the entire country, made by the military government of the country, while the edict is enacted and made by the military government of a state during a military regime. Bylaws are those by the local government council during the military or democratic regime. So remember, we have the constitutions, we have the acts, we have the decrees, we have the laws, the edits, and then the bylaws, right? So when you see laws and edits, you know that these are by the states. One, when it was the democratic government, the other military government, then the bylaws, local government council, right? So the customary law. Remember, all these we just listed are under the Nigerian legislation, which is under the sources of Nigerian law. So the customary law, before I move further, is there any question? Any question? Okay, no question. So I'm going to move. The customary law is the body of law or principles, body of rules or principles regarded as obligatory by a member of a particular community. So remember, we said common law was common to the entire England, but the customary law is specific to a particular community. So it varies from one community to another. What is obtainable in a community or a cultural setting of a particular community might not be the same thing with the next community. So while the common law is common to everyone, the customary law is specific and varies from community to community. So there is two type of customary law. They have the ethnic customary law, which apply to members of a particular ethnicity, that's ethnic group. For example, the Igbos, the Baggies, the Yorubas, members of a particular ethnic group. Then we have the Islamic customary law, which is based on the Islamic faith. So always remember that there are two types of customary laws. The first is ethnic, which applies to people of a particular ethnic group, and the second is the Islamic, which is based on the Islamic faith. So the characteristics of the customary law, the first one is that it is mostly but when it comes to the ethnic laws, there are some unwritten laws. It can be a law that when a person die, is shared by just his male children, or his properties should be possessed by his family member. There might be a law like that in a particular community, but there's most times no written law that shows that. People of the community are aware of all these laws. That's why it's called a customary law. It applies to just a particular community, right? The members of the community or group to which it relates generally consider it binding. Like I said, it might not be written, but then they are well aware of these laws and they abide by such laws. So it's those communities. For example, if in a particular community they said, "Oh, when a person's die, is properties should be possessed by his family members," everybody is aware of that law, and you will naturally see that if something happened to somebody, the people in the community will just hand over the property to his family members, right? So it is binding on members of such community, and it is established through ancestors or authoritative books. So it is established through ancestral or authoritative book, and it is largely flexible because unlike constitution, which is rigid, we need a lot of formalities to be amended. This is largely unwritten, and of course, the people of the community can come together and say, "Oh, this law is no longer favorable. Can we adjust? Can we all that?" So, Osborne CJ, in the case of Lewis versus Bankole, it said one of the most striking features of the customary law is its flexibility. It is one of the very flexible kind of law. It is one of the flexible kind of law, the most flexible kind of law. So, the validity of the customary law. First of all, the court does not recognize and enforce all custom automatically. So there have to be like a validity test that has been laid down. So when these laws pass through this test, they are now recognized by the court of law. So these tests include the Gansi tests, the incompatibility test, and the public policy tests. The pregnancy tests, the incompatibility tests, and the public policy tests. So, first off, the pregnancy test. So, this is basically saying that this law should be repugnant to natural justice, equity, and good conscience. It means it should be fair. It should be just. It should be just, and it should be in good conscience. That's like the doctrine of equity, fairness, and justice, right? So any customary law that is barbaric and falls below civilized standard of behavior would be invalid as contrary to the natural justice. So, for example, the law, after looking at it, you discover that it's too barbaric, it's too unjust, it will be considered invalid. Let's look at this case. In the case of Edet versus Essien, Essien married X after paying dowry on her. Later, X deserted Essien and without a refund of the dowry. You know, when someone gets married, you pay dowry, and when you want to divorce the traditional way, the dowry is being refunded back to the person. So X did not refund the dowry back to Essien and went ahead to marry Edet. So two children were born out of the relationship between X and Edet, and Essien claimed those children as his on the basis of an existing custom that provided that as long as the dowry paid on a woman has not been refunded, any children born by that woman belong to the former husband whose dowry has not been refunded. So the court held that such custom was unenforceable because it is repugnant to the natural justice, equity, and good conscience. So in this case, what basically happened? I don't know if you have heard of this custom. I've heard about it for more than three different ethnic groups in Nigeria. So once a dowry is paid on a lady, right, and even though the woman eventually leaves the man and all that, probably went to marry another person like this person, like X did here, as long as the dowry have not been refunded, all the children that the woman will give birth to, same according to the tradition, belong to the first husband. So that's why most times, immediately a woman leave her husband's house, the dowry is being refunded by the family members. So should in case the person should marry another person, another dowry is going to be paid. So it's basically saying that the person that paid the dowry that has not been funded is the owner of the children. But the law was like, the court was like, no, this is not just, this is not equity, and this is not in good causes. So this was not enforced in this case. I don't know if you get, it did not pass the repugnancy test. There's also another case, F Young and Actang, F Young Angtang, F Young Atta, where the court held that a custom whereby a former owner of a servant was entitled to administer the personal property of the deceased servant will fail the impugnant test, not only because it was unfair to the biological children of the servant, but also because the institution of slavery, which is adjourned, barbaric and not civilized. So this is talking about a tradition where if a servant of a particular household dies, the master has the right to, take over the property of that servant and administer it the way he wants to, right? But the court is saying that this is unjust and unfair to the biological children of that servant, and apart from it being unjust and unfair to the children, the institution of slavery as a whole is a barbaric practice, and it is not civilized. And as such customs cannot be administered by the court. It says that customary laws have to pass through to be recognized by the court. The next is sorry. The next is the incompatibility test, right? By law courts. The the next one is the proof of the customary law. So, so it is a question of if of the customary law, if someone wants to enforce of the customary law in the law court, he must prove that such a rule exists. So it's not just by coming to say, oh, in my village, this is how it is done. Da 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 da. This is done. There must be proof that, oh, there is actually an existence of such a rule, right? To avoid a lot of things. That is being played out in Argo versus Atta, 1916. where it was said that, as in the case of all customary law, it has to be proved in the first instance by calling witnesses acquaintance with the native custom until the particular custom have, by frequent proof in the court, becomes so notorious traditionalism. So it's not just like saying, oh yes, in our ethnic group, this is what is obtainable, this is a law. There have to be witnesses, series of witnesses that are acquainted with the native custom that can come before the law courts and serve as an evidence that this law is actually in existence. So it's not the kind of law where one person will say, oh yeah, this is how it is done. Then the next person will come and say, no, that's not how it is done. So it has not passed the proof. It has not been proved. Its existence has not been proved. So the next is the public policy tests. The public policy test. This is basically saying that these rules should not be contrary to the public policy, right? A rule of the customary law should not be in contrary to the public policy. So, from from decided cases such as Aleke versus Pratt and Cole versus Akinyele, the court has refused to enforce certain rule of customary law because, in the opinion of the court, they would encourage promiscuity, which is contrary to the public good. So it's basically saying that, okay, this rule, is it contrary to the public policy? Is it contrary to public good? Like, from looking at it from the court perspective, is this good from public point of view? So, an example is the observation of a child born by acknowledgement of paternity by the father. So there are some processes with parents. This involve calling witnesses as when they're calling witnesses, probably either calling to serve as witnesses, people that are knowledgeable or custodian of the customs. For all community, the chief or the king is referred to as the custodian of the custom. So those are the people called to give direct oral evidence. So there will be witnesses in such cases. Then they have the documentary evidence. These are evidence that have been documented, such as books, manuscripts, or research findings, right, by people considered as experts or knowledgeable in the custom. This can be historians that have been considered to be experts in this particular custom. Then there's the judicial notice. In trying to prove a custom by judicial notice, a person is simply asking the court to accept the custom as existing because a higher or coordinate court had in previous proceeding accepted the custom. It's just like saying, okay, if, for example, high court or which court, or let's use Supreme Court, the highest court, existence of a particular rule and applied it in a previous case. What the hell happened? Hello? It seems I went off for a while. Please, can someone let me know where I stopped? Can you hear me now? Can I? Hello, Glory. Can you hear me? Okay. I cannot really tell when I was cut off, but at some point it seems I was cut off. So I'm just going to continue from the judicial precedent or case law. So, like I was saying, this refers to a decision of a court that establish a principle of law. The source of law is also known as case law. So it can be called judicial precedent or um, case law. It is the application of the principle stare decisis, which means stand by what I've said. So it's basically saying, oh, if there is a case, let's say a high court have a case that is similar, and you're coming to a lower court. So the lower court will basically use the judgment of the high court and say, okay, this is what I've been decided. So we are going to apply it to this case. I don't know if you get what I'm trying to say. So the lower courts are bound to follow the decision of the superior court in cases that have similar facts. This promotes the sanctity of law among other advantages. So there's something called the ratio densidity and obiter dictum. Sorry about the pronunciation. But then, so in this case, it is not all the part of the past decision that is used as a precedent. It's only the material fact. Okay, that fact that's about, oh, this particular fact is material enough to this case. So it will constitute a precedent, right? So the remainder parts of the decisions which does not constitute, which are not material, they need not to be followed. They are called arbiter dictum. Sorry for the plenty, but then the part that decisions being taken, which was called a precedence, are called the arbiter dictum. This is a statement, by the way, or other remarks that the court made in the course of the um, proceedings. So, although in case law and precedent, most times we make use of all the facts, but there are some cases where only the material fact, that's part of decisions that concerns the case at hand, right? So we are moving to the type of precedents. The type of precedents we have three types of precedents. We have three types of precedents. We have the original precedent and the persuasive precedent. So the original precedent is if the point of the law in the case have never been decided before. So whatever the judge decides forms the original precedent. It's just like saying, oh, this kind of case have not been judged on before. So this is basically the first of its kind, the pioneer. So whatever the judge decides in that case forms the original precedent for the future cases, right? So a binding precedent emanates from the decision of a superior court. So when the Supreme Court make a decision and the High Court probably have something similar, it the precedent set by the Supreme Court become binding on the High Court. I don't know if you are getting the analogy. Then they have the persuasive precedent. They have the persuasive precedent. So this is not binding like the binding precedent, but it's persuasive. So it might be between two courts of coordinate jurisdictions. For example, the High Court of Abuja and the High Court of River, or the High Court of Rivers and the High Court of Lagos. So there's a decision in the High Court of Lagos, and then the High Court of Abuja can be persuaded to apply the same, to use that case as a precedent. I don't know if we're getting if we're getting the analogy. The original precedent is like, okay, these have not been decided on before. This is the first decision being made. The binding is saying, oh, the higher courts have made a decision, so the lower courts are being bounded by that decision. They must use that as a precedent for similar cases. Then the persuasive is saying, okay, these are two courts of this same, of similar two courts in different jurisdictions. That, for example, high courts in Abuja and high court in Nassau State, or high court in Lagos, high court in Ogun State. So one of them have been able to make a decision on a particular kind of case. So the high court in Abuja might be persuaded to use that as a precedent for other cases. So we are going to be looking at the terminologies in precedent. Terminologies in precedent. We have distinguishing. It means that a judge finds that the fact of this case is deciding are materially and sufficiently different for him to draw a distinction between the present case and the previous case. It's basically saying that, okay, oh, this previous case that have been decided on and the case that I'm presiding over, they are different. They are distinguished based on the facts of the case. So it's looking at the fact of that case and the fact of this case and say, okay, oh, they are materially and sufficiently different. I don't know if you get. Then the next is the overruling. This is when the same courts that made the previous rule overrules the previous rule and make a new rule. So it's basically trying to repeal the previous rule. You know, in legislations we use the word repeal when a new act is made to overrule the other. So this one is nullification of a previous decision by the same court. Bear in mind, the same court, a superior court, or a statute. That's a legislation. So it's either the same court, a superior or a statute. A lower court can rule. This happens when a higher court in the hierarchy of the court overturns the decision of a lower court on appeal. So this is like decision was made in the customary court. So you went to the high court and the high court overturns that decision, or the appeal court of appeal overturns that decision. It's basically saying, oh, that decisions should be reversed. Yeah. Then the next is per incurrium. This is a description of a decision made in error or mistake. So it is one of the reasons that a court will have to overrule a previous decision. So if the decision have probably been made in error and it has been examined to be made in error, it can be overruled. And when such a thing happens, such a decision is called a per incurrium, right? So the advantages of the judicial precedents and disadvantages of the judicial precedent. I don't know if you can hear me. Okay, we are just two here now. I would have loved to actually be asking as I go, but since we are just two, I'll just try to keep explaining. In the next class, I would love to have maximum attendance so that I can basically know if you understood what I'm trying to explain, right? So the advantages, it makes law certain as it enables people to know the law on a particular subject matter and how it affects them. So it gives that foundation. Once there's precedence, you'll be able to know that, okay, if such a thing happen, this is what the court will decide. This is what applies to this particular subject matter, and this is how it's going to affect me, right? And it makes the law consistent. So it's not like today the courts agreed and made a decision that so and so should happen in favor of this person. Then the next day, because there's no a decision in favor of precedent, enables that laws are consistent and fair, and similar cases are decided similarly. And it saves the time of the court. So instead of trying to decide on, okay, what should do, it just use the precedents and make it easier for both lawyers, the people involved, and the court as a whole. So the disadvantages of the judicial precedent. It makes law rigid and mechanical, since the lower court must follow the decision of the higher court. So the lower courts are binded, remember, binding precedent by the decision of the higher court. So they cannot change what have been decided on. So it's very rigid. It leads to loss of initiative, especially on the lower court judges. So they are just blinded by the decision of higher court. So they don't have initiative. Anything the high court say, okay, that's what we're going to apply. And the use of distinguishing to avoid past decision can lead to illogical distinction So it's just like saying, oh, remember the situation is trying to say, oh, based on the facts, they are not the same thing. So they can try to bring out illogical, illogical reasons just to get distinction, right? And it is not always easy to find the relevant case law. Lawyers who attest to this. That's why you always see lawyers doing research and research, trying to find if there have been a precedent to that particular case. Because most times, when there are precedences on a particular subject matter and it is favorable to you, it will give you like a basis on which to argue your case, right? So although it makes the law consistent and it saves the time of the court, but it is difficult to find a particular or relevant case law that might not be thrown out as distinguished. I don't know if you get. Might not be thrown out that, oh, no, based on the fact these are not the same thing, these are two different cases and all that. And it may lead to slow development of the legal system, as the appeal process are usually long or may be long, and the applicable law may not be clear quickly. So the application of the doctrine of judicial precedence within the Nigerian court system. For an effective operation of the doctrine of precedence, two essential conditions must be satisfied. The first one is that a settled and good hierarchy of courts, and the second is a good law reporting system. So the two conditions, remember, is a settled and good hierarchy of courts and a good law reporting system. These are the conditions that must be satisfied before an effective operation of the doctrine of precedent. So if there is no good hierarchy of courts, it will be unclear as to which court is higher, which court is lower. Okay, which precedent is binded on me, which is not binded on me. And then the cases must be reported accurately. So there must be a good reporting system, good law reporting system. So it will be easy for every court to see, oh, there have been a case in so and so higher court that applies to this case at hand, right? So the judicial power is conferred on courts in Nigeria by Chapter 5 of the Constitution of the Federal Republic of Nigeria. So the courts are the formal institutions responsible for complete resolution and interpretation of the law. That's the judicial arm of government. There's a settled hierarchy of courts in Nigeria, a clear line of appeal from the lowest court to the highest court. So we look at the classification of courts. They might be classified as court of records and courts other than courts of records, superior courts and inferior courts. So court of records are courts that have records of their proceeding. Why courts other than courts of record are those that do not keep records of their proceeding. Although in Nigeria now, almost all the courts, yeah, I think almost all the courts have records of their proceeding in Nigeria now. So the major distinction between these courts is that courts of record have the power to punish for contempt committed both within and outside of the court. So you can hear, oh, so person have been held in contempt of the court. So the courts of records have the power to hold someone in contempt, punish for contempt committed. But then courts other than courts of records cannot punish for contempt contempt committed outside the court. So the first one can hold you for contempt whether within or outside the court, as long as you're in contempt to the courts. They can punish you. But the ones that don't have other than the courts with records can only punish you for the contempt committed within the courtroom. So the second classification is the superior and the inferior courts. The superior courts have unlimited jurisdiction. This is the Supreme Court, the Court of Appeal, and Federal High Court, Customary Court of Appeal, the Sharia Court of Appeal, the National Industrial Court, and all that. Then the inferior courts are courts with limited jurisdictions, right? Include the Court of the Magistrate Court, the District Court, and so on and so forth. So the two distinguishing factors, you should just remember that superior court, unlimited jurisdiction. Then the opposite is the inferior court. Then for the court of record and courts other than court of record, you just know that okay, court of record can punish for contempt with the committed within and outside the court, while the other one it is just within. Then the hierarchy of courts. The hierarchy of courts. This is the order of superiority of the courts within the judicial system. This is basically trying to show, okay, which court is higher than the other? Which court is the lower? After this court, what is the next higher court? After this court, what is the next higher court? So the Court of Nigeria in the order of the superiority. So we are starting from the highest to the lowest. The highest and final court. Any decision made in the Supreme Court is binding on all other courts. That is the Supreme Court of Nigeria. This is the highest and the final court in the hierarchy. Decision of this court constitute a binding precedent. Yes. So it is binding on all other courts since this is the highest court. So the Court of Appeal, every other court is below the Supreme Court. So it's just like Central Bank of Nigeria, that is the peak of the banking system. The Supreme Court is the highest and the final court in Nigeria, the Supreme Court of Nigeria. So the Supreme Court may depart from its previous decision in the following circumstances. When the previous decision was reached by incorium, and when there are two conflicting past decisions of the court. So if, for example, the Supreme Court made a decision and there is another decision, the two of them are based on cases with similar facts, but then they are conflicting. One of the courts will overrule one and follow the other. Since it's the Supreme Court, it's going to overrule one. If, for example, the first one was I'm trying to look for a case. Let's just say the first one was in favor of plaintiff A, but then the second one, same case facts. The case and case facts are different things. Same case fact, but then the decision was not in favor of the respondents, right? These decisions are conflicting. So the court will have to come and say, okay, we have two conflicting decisions. Which one are we overruling and which one are we going to follow, right? So the next court, just below the Supreme Court, is the Court of Appeal. The Court of Appeal is bound by decisions of the Supreme Court, and the Court of Appeal decisions must be followed by all other courts below it. So after the Supreme Court, you have the Court of Appeal. And when there is a conflicting decision of the Court of Appeal, the court could choose which one it will follow and which one it will reject, right? So there's a Federal High Court that is below the Supreme Court, also known as the Federal Revenue Court. So when you hear Federal High Court and Federal Revenue Court, you should know they are the same thing. It was established in 1973, but renamed as the Federal High Court in 1976 and retained by Section 249 of the Constitution. According to the Constitution, Section 250 of the Constitution, the Federal High Court have exclusive original jurisdictions. It has exclusive original jurisdictions in all matters pertaining to one, the revenue of the government of the federation. So when there's a matter or case that concerns the revenue of the government of the federation, it is under the jurisdiction of the Federal High Court. The taxation of companies and persons that are subject to federal taxation. So if, for example, we know that individual taxes are remitted to states' inland revenue, but then military personnel and the and persons in the Federal Capital Territory are subjected to federation tax, like their tax are being paid to, as at the last tax law. I'm not talking about the current one now. To FIRS, known as FIRS, yes. So if there's any issue with regards to the taxation of company, if for example there's a dispute between a company and the taxation collection agency, right? The matter is going to be under the jurisdiction of the Federal High Court. Customs and exercise duties, any issue concerning this is under the jurisdiction of the Federal High Court. Banking, banks, and other financial institutions, any action by or against the Central Bank of Nigeria is under its jurisdictions. Any admiralty matter, citizenship, naturalizations, passport, visas, bankruptcy, insolvency, aviation and safety of aircraft, arms, ammunition and explosive, drugs and poison, etc., are all under the jurisdictions of the Federal High Court. Bear in mind, it was also called the Federal Revenue Court. And treason, like when someone is a traitor, when someone betrays the country, this is under the jurisdiction of the Federal High Court. And after the Federal High Court, the next court under the hierarchy is the State High Court. The State High Court. This is a court of record with unlimited original jurisdiction in both civil and criminal cases, right? And can exercise appellants jurisdiction on decisions of inferior courts such as the magistrate court, the district court, and so on. So it was that in FCT for the Federal Capital of the Capital Territory was established by Section 225 of the 1999 Constitution. So in this course, you are going to be seeing a lot of section. I know we're ICAN student, but then we are going to be transforming into a little bit of law students with this course. So we are going to see a lot of sections, a lot of cases, and a lot of law jargons, right? So the ICAN is basically trying to teach you on the legal aspect of the profession. So, like I was saying, the state high court is just below the federal high court, and its original jurisdiction is in respect of civil cases, matters including the determination of titles, ownership of lands, divorce petition, and other civil matters. Other than that, under the jurisdiction of the federal high court. Then remember I said it has both jurisdiction on both civil and criminal cases. So those are the civil cases. Then the criminal cases include felony and offenses such as murder, armed robbery, rape, theft, fraud, corruption, and the likes of that. Then we have what is called the Sharia Court of Appeal. The Sharia Court of Appeal was established by Section 260, another section, Section 260 of the 1999 Constitution, establishes for the Federal Capital Territory a Sharia Court of Appeal. Section 275 of the Constitution also provides that there shall be for any state that requires it a Sharia Court of Appeal. So while Section 260 established that of the Federal Capital Territory, Section 275 established gave a clause that enables the establishment of Sharia court for any state. It says for any state that requires it. For any state that requires it, yeah. So they basically deals with areas involving the Islamic personal law. That's anything under the Islamic law, like marriages, succession, guardianship. It's basically its jurisdiction is basically the Islamic law. So when you see Sharia Court of Appeal, you know that okay, yes, this has to do with the Islamic law. Don't forget. Then they have the customary court of appeal. This was there was a clause that provides for the establishment of customary court of appeal, which is section 280, remember, of the 1999 Constitution. It provides that there shall be for any state that requires it a customary court of appeal for that state. So if a state requires a customary court of appeal, it can be established based on this clause, right? And it has appellate and supervisory jurisdiction over the proceedings coming on appeal from the customary courts. So it can only legislate, it only have jurisdictions over appeal coming from the customary um courts on question of customary law. Sorry. Of on question of customary law, such as inheritance, marriage, and all that are under the customary law. So why the Sharia law of appeal is deals with the Islamic law, customary court of appeal deals with customary law, right? Remember, Islamic law is a branch of customary law, but then it is that customary law that is written, others are not well written. Then the next under the hierarchy is the Nigerian Industrial Courts. The Nigerian Industrial Courts. But before I proceed, I don't know, Glory, do you have any question? If there's no question, then I can proceed. Okay. The National Industrial Courts was first established by the Trade Dispute Act 1976. The Trade Dispute Act 1976. And why was it established? It was established to serve as the final arbitration court in labor and industrial relation disputes. In labor and industrial relation disputes. So before the enactment of the National Industrial Court Act 2006, before the enactment of the National Industrial Court Act 2006, matters could only reach the court through referral by the Ministry of Labour and Employment, either directly or indirectly. But now, through the National Industrial Court Act, it has remediated that fundamental anomaly. So now, aggrieved parties can take their complaint directly to the National Industrial Act. So before this industrial court, so before this act came into play, it was only the Minister of Labour and Employment that can send matters to this court. That's through the referral of the minister. But after the enactment of this act in 2006, now aggrieved parties can take their complaint directly to the National Industrial Court without reference from the minister. So you have the Federal High Court, the State High Court, the National Industrial Court, Customary Court of Appeal, and the Sharia Court of Appeal. All these courts are courts of coordinate jurisdiction, and they are on the same level. And this is directly below the Supreme Court. Remember, we are on the hierarchy of court. So the Federal High Court, the State High Court, the National Industrial Court, the Customary Court of Appeal, and the Sharia Court of Appeal, they are courts of coordinate jurisdictions and on the same level. So a decision on one of these is not binding on the other. The decision of the Supreme Court is binding on this, and decision on these courts are binding on lower courts, right? So the next is the magistrate or the district court. These courts must follow the decisions of all the courts above them. So the magistrate courts, the decisions of the Federal High Court, the Supreme Court, the Federal High Court, the State High Court, and all the courts that have been previously mentioned are binding on the magistrate courts. But the decision of the magistrate courts, right, are not binding on the courts below. Example of courts below are the customary courts, the area court, the Sharia courts, and all that. So the district court. So some states in the former northern region of Nigeria, that's the northern part of Nigeria, have courts known as the district courts. A single judge constitutes this court, and the district court is a court of civil jurisdiction, so it does not has jurisdictions over criminal cases, but only civil cases, right? But only civil cases. Then the next is the customary courts or the area courts. So this court handles matters of customary law. from the name you can tell that this has to do with matters that involve the customary law. And the customary courts are found in the south. The equivalents in the north are called the area courts. So each of the courts have its own law that defines the jurisdictions, compositions, and procedures of the respective court. So, for example, the customary court of law, the customary court law of Lagos State, provide that subject to the approval of the governor of the state, the attorney general may establish such number of customary courts, grade A and grade B, as it is customary courts shall be the State Judicial Service Commission is vested with the power and that. So what I'm trying to explain is that this law applies to customary courts in Lagos. So that's in Edo State. We have some this. So remember, we are still under sources of law, and we just finished case law and precedents. Yeah. So is there any question? Any question? Okay. So international law. This sorry a moment. So bilateral and multilateral treaties. When you hear bilateral, you know that it's more than two. Multilateral, as well as convention, as well as global and regional charters, form part of the Nigerian law once the Nigeria Assembly passes an enabling status to that effect. So it's just like saying international laws, right, that are not for a particular country, they form part of Nigerian law when the National Assembly have passed a treaty, sorry, have passed an enabling status to that effect. So the case of Inspector General of Police versus the All People's Party 2007 held that the African Charter on Human and People Rights applies in Nigeria by the virtue of the Africa Charter on Human and People's Rights Ratification and Enforcement Act 1990. So what basically happened was that this African Charter on Human and People's Rights was now passed in Nigeria, ratified and enforced in Nigeria. So as such, it applies and can be enforced in Nigeria and form part of the Nigerian law, right? So the legislative processes, that's nexus. The legislative process is basically saying the laws pass into acts or the bills passed by the National Assembly. And this is obtainable in a democratic government. So you usually start with introduction of a bill. So introduction of a bill in either of the two national assemblies either the Senate or the House of Rep or the House of Assembly of a state. So there are two types of bill. A bill is a proposal. I know you usually hear, social bill have passed. Social bill have passed the first hearing, have passed the second hearing. A bill is a proposal. The public will affect the interest of the public, right? So while the public will affect the interest of the public, that's the entire citizens and everybody, the private bill affects the interest of a particular group. So you can say, okay, things like education, things like housing affect the entire public, right? So any bill that has to do with this subject matters are public bills. But bills that affect, just for example, ASU, that's professors or doctors, these are private bills that affect the interest particular of a particular group of persons. So when the bill is drafted, it has to pass through the first reading. It's a formal procedure where the names and the main aims of the bills are read out. No decision is taken at this place. It's just like an introduction of the bill is to the legislatives. So the House will now vote on, okay, should they consider the bill or not. There's usually no discussion. It is just read out and it is decided on whether it should pass to the second reading or not. So when it is decided to pass to the second reading, it now goes to the next stage, which is the second reading. It is the stage where the House debates the principles behind the bill. The debate usually focus on the main principle rather than the details. So they'll say, okay, what is the principle of this bill? What is the principle of this bill? They will not first of all look at the in-depth, right? The first reading is just reading out the bill. They will not discuss it. They'll say, okay, should we consider this? Should we not consider this? The second, the second is, okay, let's look at the principle of this bill. Should it be passed for further progresses or not? So if at the end of the day, the votes say, okay, let's pass this for majority vote in support of the bill, so it progresses to the next stage, which is the committed stage. So at the committee stage, sorry, a detailed examination is done. So the bill is undertaken by a committee. A standard committee is selected. It's just like, okay, so bill, let's say the tax reform, then the tax committee is now selected. Then they'll now go back and do an in-depth analysis, detailed examination of the bill. Then it will now proceed to the next stage, which is the report stage. So at the committee stage, amendment to various clauses, the committee will look at it and say, okay, they should amend this clause, they should not amend this clause. Then they will now come, bring their reports to the House of Rep. So remember, it has passed through the first stage, passed through the first reading, second reading, committee stage, and now the committee is coming to report on the examination and the amendment that have been done. So after this, then it is after this it goes to the next stage, which is the third reading. So when there is a request from a certain numbers of the members, according to the rules of the House, this stage is almost a formality, right? It's almost like a formality. It's just take the final look at the bill and final vote. Remember, at the committee and report stage, there have been some amendments, some decisions, some examinations and all that on the bill. So the third reading is just like, okay, formality, the final reading, the final vote is taken on it, and then it is sent to the president for the stage called the president's assent. So it is the president that signs this bill into an act. So the president can exercise his veto power and refuse to sign the bill. But this power can only last for 30 days. And the power can be defeated if there's a joint section of the two houses and the veto power to say, oh, I don't want to sign this into law, and this lasts for 30 days. And then the two House of Assembly, that's the Senate and the House of Rep, can decide to say, oh, let's have a joint section and override the veto power. And this can only be overruled or overthrown by two-third majority votes of the combined house. Two-third majority vote of the combined house. So this have been for the federal level. The same procedure is applies to the state level. And the state level is, of course, is the governor and not the president, right? So, any question? Okay. If no question, we are going to look at the next subtopic, which is the division of the legislative power between the federal government and the state government. Division of the legislative power between the federal government and the state government. Remember, I said something about the exclusive list and the concurrent list earlier in the class, right? So, under the 1999 Constitution, under the 1999 Constitution, legislative powers between the National Assembly, that is the federal, and the State House of Assembly are divided into three lists. You have the exclusive legislative list, the concurrent legislative list, and the residual legislative list. So the exclusive legislative list, the list contains matters on which only, remember I said earlier that it's the federal that has jurisdiction on exclusive legislative list. Only the National Assembly can make laws to the exclusion of any of the states. This includes defense, currency, immigration, citizenship, aviation, customs, and exercise, right? Then the concurrent legislative list. This list contains matters on which both the National Assembly and the State House of Assembly could make laws side by side. For example, education, tourism, agriculture. So it should be noted that if there's actually a conflict between the National Assembly law, that's the act, and the law made by the State House of Assembly, the act shall prevail. So since if there's a discrepancy between the act and the law, remember, act is by the National Assembly, law is by the State House of Assembly. So if there's a discrepancy, the act will always have the upper hand. It always prevail and render the state law non and void. Always have that at the back of your mind. Then there's residual legislative list. It contains matters which only the House of Assembly of a state can make decision. This is basically on a grassroots level. You have local government administration, chieftaincy matters, market administration, and etc. So the residual legislative list deals with matters that are more on the grassroots level. So the National Assembly does not have jurisdiction on such matters, right? So it's just easy to know that, okay, exclusive list is for the National Assembly alone. Concurrent, there's a cohabitation between the National Assembly and the State Assembly, so they can make laws side by side. But if there's a conflict, the acts of the National Assembly overrides that of the State Assembly. Then the residual are those grassroots matters like local government, chieftaincy matters, market administration, and so on. And it's State House of Assembly that has jurisdictions over that list. Yeah. So we have actually looked at a lot. But then, if there's no question, which I assume there is none, we are going to move to the next. You can always ask your question later on, maybe for those that will watch the recording later in the day. You can always ask your question, and then I will be happy to answer. So, there's a distinction between a criminal law and a civil law. I don't know if you usually watch legal related stuff or you read legal book. You usually see, oh, this is a criminal case, this is a civil case. So there's a criminal law and there's a civil law. Criminal law creates offenses. So an offense is an act that is punishable by a statute. That it is punishable by a law, a statute. There's a statute that punish such offenses, right? Such acts. While the civil law, on the other hand, it guides the rights and the interests of citizens in their interpersonal relationship. Why this one creates offenses? This one is trying to guide the interests and the rights of citizens in interpersonal relationship. So the aim of this criminal law is the punishment of an offender, either by imprisonment or imposition of fine, or imprisonment and imposition of fine, right? Why the aim of the civil law is to grant compensation to the injured or aggrieved party. So in the case of in the case of criminal law, at the end of the day, if the person is found guilty, is sentenced probably to prison, or a huge fine is imposed on the person, right? But for civil law, the aim is not to send someone to prison. The aim is to get compensation of the injured or the aggrieved person. So if, for example, you are suing a company to court on a civil basis, probably you use the product and it causes some injury or some I'm trying to remember what it's called, damages, right? So at the end of the day, the court is going to grant compensation for that damages, right? Then the third differences is that in criminal law, a standard proof is a proof beyond reasonable doubt. So your proof should be beyond reasonable doubt. There should not be any doubt from this proof. But in civil law, the standard of proof is preponderance of evidence or balance of probability. So it's just like, okay, let's look at it. What's the probability of this and that? Yes. But then for criminal law, you must prove beyond reasonable doubt. Beyond, take note of beyond reasonable doubt, right? So the next distinction or differences is that in criminal case, there is no limitation of time during which a defendant could be prosecuted for an offense he has committed. There is no limitation. Maybe he committed an offense last 10 years ago, then he has been the case is in court now, so there's no limitation of time during which a defendant could be prosecuted. But in civil cases, there is a time limit in which a plaintiff must institute an action against the defendant, and it usually ranges from 6 to 12 years. So if it's above 12 years, you know that, oh, you have exhausted the limit, the case limit. Then the next this differences is that the decision to prosecute a person in a criminal matter is taken by the state that prosecute the offender on behalf of the victim. But then in civil cases, it is made by the aggrieved or injured party. So this is what it means. When you hear a case like the state versus so person, the state versus so person, you will know that, oh, this is a criminal law because the state prosecutes the person on behalf of the victim. So in case of murder, in case of rape, case of armed robbery, the states are the ones with the decision to prosecute or not to prosecute. But in the case of the civil law, the person, which is the plaintiff, is the one with the decision on whether to prosecute or not prosecute. So those are basically some of the differences. Another difference is that the parties of the criminal proceedings are the state and the accused defender. Then the others is for the civil proceeding is plaintiff and defendants. Like I said, when you hear state versus this, you know that this is a criminal case. But when you hear, okay, Edet versus Essian, this versus this, you know that, oh, this is likely a civil case because these have the state and the accused, that's the defendant. Then these other ones have the plaintiff and the defendant, right? So the next is the application of the virtual evidence in the Nigerian judicial system. So the virtual evidence is given by witnesses from remote location. When we say virtual, you know that, okay, this person is not coming physically to the court, probably for reasons well proven. Maybe the person is not able to come to the court to give those evidences. There are three ways. It's either through audio hearing, that's audio conferencing technology, video or virtual hearing, that's video conferencing, Zoom, Skype, Teams, and all that, or paper hearing through submission and exchange of electronic writing, or online delivery of judgment through the same means. So this paper hearing applies when not only the evidence but also judgments are being delivered through the same means. So it's either electronic writings or paper. So the virtual hearing become compelling with the coming of COVID-19. You can remember during the COVID-19, people were not able to, come physically for a lot of things. So that was what allowed the admissibility of virtual hearing. It became quite common in the courtrooms, right? So yeah, the theory ways: audio, video, paper. Remember, just try to remember audio, video, paper, and if something like this is asked, you'll be able to know, oh, audio, video, paper. Then you can always explain, oh, video like Zoom, video like Skype, Teams, audio conferencing technology. Then paper, you know that say, okay, the evidence is writing, the judgment is also through the same means. So the Cyber Crime Act 2015. The Cyber Crime Act 2015 was enacted to combat the rise of cybercrime. So it requires, among other things, the internet service providers keep all traffic data and subscribers' information, and court orders authorize interception of electronic communication that could support criminal proceedings or investigations. So this act was enacted to combat cybercrime. Due to the advent of technology, internet, there have been a rise of cyber crimes, and the federal government of Nigeria deemed it fit to enact a law that can combat the rise of cyber crimes. So this act make criminal and penalizes the following: identity theft. Identity theft is simply when someone steals the identity of another person, basically through accessing the person's cyber information, online information, and uses it for its own selfish gain. Sometimes they steal someone's identity, take loans, steal another person's identity, defraud people, like, and do all sorts of criminal activity. So this identity theft on its own attracts imprisonment of a term of not less than 3 years, or a fine of not less than 7 million, or depending on the case, you might be required to pay both the fine and go to prison. So not less than 3 years of imprisonment, fine is no less than 7 million. So offenses committed against computer system, network, and information infrastructure that the President of the Federal Republic of Nigeria designates critical national infrastructure. So this means that for offenses that are against those systems that have been designated to be national infrastructure, it is punishable by death. So if any offense of such comes up, the punishment is not prison, it's not fine, it's death. Then hacking of a computer system, including internet fraud, is punishable with a fine of 10 million naira or a term of 5 years imprisonment. So you're either paying 10 million naira or you're going to prison for 5 years. Of a term for a term of imprisonment, or to both such fine and imprisonment, right? So it's either a fine or imprisonment, or fine and imprisonment. Then we have cyber squatting. So cyber squatting, that is registering or using internet domain names with criminal intent. Registering or using internet domain name with criminal intent so as to profit from another's good mark or trademark. This is like you are registering a domain name that is very similar, or you're using someone trademark to register a domain name. and automatically you know that the world is very digital now. The world is very digital now. So somebody might want to, maybe it's a NGO or something, and the person will like, oh, let me just send through the website, right? And they are coming to the website and they are seeing a domain name and say, oh, this is probably it. This is probably it. But then that is like a fake website. I know that would have probably seen a lot of it. There was a time that some organization will come out and say, oh, this is not our website, or put a link there and say this is the correct domain name. That is cyber squatting, right? This is punishable with not less than 2 year imprisonment, or a fine of not less than 5 million, or both. Notice in almost all, it's either one or the two, depending on the severity of the crime. Distribution distribution to the public of racist and xenophobic material, which attracts a fine of not less than 10 million. You know, when you are distributing racist materials or xenophobic materials, the fine is not less than 10 million or imprisonment of not less than 5 years, or both. So it's either one or the two of them. Then child pornography attracts 10 years imprisonment or a fine of not less than 20 million naira, or both, depending on the severity. Right. So I'm assuming there's no question. Is there any question? Okay, so no question. We'll move to the next subtopic, which we'll use to end this class today. Remember, today is just like an introductory class, and subsequently, I'm going to be distributing the material, a summarized version. I'm currently working on it, but then before the next class, you get the one for this class and the next class, and probably before, as soon as I'm done with the entire material, I'll try to compile and send. Right. So the last subtopic here is the governing principle of the Nigerian Data Protection Regulation 2019. Remember, the one we treated before is the Nigerian Cybercrime Act 2015. This is the Nigerian Data Protection Regulation 2019, which was issued by NITA, that's the National Information Technology Development Agency. It is in pursuant to its enabling power under the NIDA Act 2007. So without prejudice to other procedure in the regulation or any instrument for the time being, the regulation have the following principle of data processing. Number one is that personal data shall be A, collected and processed in accordance with specific, legitimate, and lawful purpose consented to by the data subject. That's why most times you see that there's terms and conditions, data protection, something, something. When you are trying to log into a particular site, you'll now see something like, okay, I consent with the terms and conditions and privacy laws and all that, right? So this is saying that personal data must be collected with consent of the data subject, provided that a full processing may be done only for archiving, scientific research, historical research, research or statistical purpose for public interest, right? And B, any person or entity carrying out or purporting to carry out data processing under the provision of this paragraph shall not transfer any personal data to any person. So even after the consent, it should only be for research. The research is scientific, statistical, or historical, or for eye carving, right? Then B, personal data shall be adequate, accurate, and without prejudice to the dignity of the human person. Without prejudice to the dignity of the human person. And personal data shall be stored only for the period within which it is reasonably needed. So even though they're archiving, if they don't need the data, they are not supposed to store it according to this law, right? And personal data shall be secure against all foreseeable hazard, such as theft, cyber attack, hacking, manipulation, and all that. Damage by fire, damage by rain, exposure to natural elements, etc. The second principle is that anyone who is entrusted with personal data of a data subject or who is in the position of a personal data of a data subject holds a duty of care to the said data subject. So as long as you are in possession of the personal data of someone or a data subject, you have a duty of care. Duty of care is just like handling handling those informations with utmost care. Yeah. And three, anyone who is entrusted with personal data of a data subject or is in the position of the personal data of a data subject shall be accountable for its acts and omission in respect of data processing in accordance with the principle contained in this regulation. So, when you are entrusted with a personal data, or if you are in the possession of personal data, you are accountable for your acts and omission in respect to data processing and in accordance with the principle of this regulation. So that is the length and breadth of the class today. I don't know if there's any question. There are some multiple choice questions under this and open-ended questions. So I'm going to send to the class so that you can go through it, try to answer them, and of course, make use of your packs and pathfinders to be able to enable you get maximum return. Of course, we as lecturer cannot give you 100%. You have to be attentive to class as if you are not reading and reading as if you don't have tutorial, so that the combined effect of both, the compounding effect, it's what is going to shoot you over the top. So I'm happy to be your lecturer for this course for the rest of the diet, and I'm pretty sure we'll be able to achieve maximum results and of course maximum pass rate. So I don't know if there's any question. If there's no question, we'll call it a day. Any question, Glory? Okay, I think there's no question. So thank you very much. Have a nice day.